Hello, and welcome back to another Men's Divorce Podcast Live. I am Kelly Burris, a senior litigation partner at Cordell Cordell. I'm based out of the Austin, Texas office, and I'm joined today by Enrico Zanella, a senior litigation attorney in the Jacksonville, Florida office.
Thanks, Kelly. I'm glad to be joining you today.
Well, thank you for joining us. For those of you who aren't familiar with the firm yet, Cordell Cordell is the world's largest domestic litigation firm of its kind, advocating for fathers before, during, and after divorce. The firm has 30 years of experience in all facets of family law, and we are a partner men can count on and have counted on for many decades. So the Men's Divorce Podcast Live, which we're presenting today, is a special monthly series hosted by Men's Divorce Podcast and sponsored by Cordell Cordell. If you'd like to listen to more topics regarding divorce or family law, subscribe to the Men's Divorce Podcast YouTube channel or listen to our latest episodes on Spotify or Apple Music. This month, Enrico and I, who combined also have 30 years of experience in family law, will answer your questions live and discuss some of what you might want to know before filing for a divorce. Sometimes it's easier in these things to learn lessons from other people's mistakes, especially when those people are famous. So maybe surprisingly, a lot of high profile celebrity divorces can have similar issues and problems to divorces that happen to everybody else. Sort of like the family law version of stars. They're just like us. So today we're going to be talking a little bit about Mel Gibson's famous divorce and what we can learn from that, and what you can learn not to do from poor Mel. So please make sure to submit your questions in the chat section on the YouTube and Facebook Live. So before we get into it, as attorneys, we love our disclaimers. So just be aware there's no attorney-client relationship established through this webinar. Every state is different. Every case is different. So we can't offer you legal advice that is specific to your case over this webinar. Consequently, we encourage you to contact our office to schedule an appointment for any legal advice. All right. Well, before we get into it, let's take a quick commercial break, and then we will come back with Mel Gibson's divorce case. All right, and we're back. Okay, so just before we get into it, let me give you a little bit of a refresher, we'll talk a little bit about what happened in this divorce case, if you don't remember it. So Mel Gibson and his first wife, Robyn Moore, met way back in the late 70s when he was filming Mad Max. She was working as a dental nurse at the time, so she wasn't really even in the industry at all. And he had just kind of started and just started getting famous. So they went on to have 7 children together. It was quite a lengthy marriage. Hannah, Christian, Edward, William, Louis, Milo, and Thomas. So the only child that was still had not aged out at the time of their divorce was Thomas, and he was 12 at the time. In 2006, Mel and Robyn separated. And 3 years later, in 2009, she filed for divorce, citing irreconcilable differences. So that's sort of a no-fault type allegation. Their divorce was finalized in late 2011, 2 years after Robyn initially filed. So I know a lot of you are thinking, hey, it may only take me like 90 days to get a divorce. It can be a little bit longer than that. So for them, it was 2 years. And they settled. And so who got what? So according to divorce paperwork, Moore sought joint physical and legal custody over their kiddo, Thomas. And it was also reported that Gibson handed over half of his multi-million-dollar fortune. They tried to keep it pretty tight and pretty quiet, but it was reported that she allegedly got $450 million in the divorce. In addition to that, he was also ordered to pay her half of his film residuals, so his royalty income, for all of the movies he'd made and all of the films he'd done during their marriage for the rest of his life. So she got half of his royalties for everything for life. Largely, this was because they didn't have a prenup. when they were younger, when they met, he wasn't super famous at that time, and they got married without a premarital agreement. It was reported that their split was one of the most expensive in Hollywood history at the time. She also received one of their homes that they shared together in Agora, Los Angeles, which she then sold in 2015. All right, so given those facts, let's discuss what Mel could have done differently and what mistakes you as if you're going through a divorce, what you could learn from. So Rico, let's talk about the prenup situation. So there are prenups and postnups. Can you talk a little bit about what the difference is between those two?
Yeah, and thank you, Kelly. I think that's the fact pattern is very interesting because I know a lot of people think, oh, celebrities, right? It doesn't apply to me, but these are going to be some really good lessons for anybody planning on getting married or even going through a divorce. Now, the first is prenuptial. Prenuptial is, as it sounds, it's going to be prior to the marriage. And in a prenuptial, it's really a contract between the two parties as it relates to assets, liabilities, spousal support, and everything in between. And the hope is that with a prenuptial agreement, you and your future spouse have some type of contract that if anything happens in the future in a divorce proceeding, in a separation proceeding, that could be taken out and really address most, if not all, of the issues in your divorce case, absent maybe the parenting issues, time sharing, and possible child support. Now, in a postnuptial agreement, this is something that takes place during a divorce, or I should say after a marriage, while the parties are still together. They're already married. And it's the same concept. It's a contract. Maybe the parties haven't contemplated a divorce yet. Maybe separation is coming, or maybe they've acquired certain assets or certain liabilities during the marriage that they want to address now, right? But really, both of them are some type of contract that is written between the two of them that's going to adjudicate what happens to the marital assets, the liabilities upon the divorce taking place or the separation taking place.
Yeah, and in Texas, we also have what's called an agreement incident to divorce. So that's one of those things is that if you're thinking about a divorce, I've had a few consults and clients come in where it's, they're not ready to get a divorce yet, but they want to, if they do get a divorce, they want to figure out ahead of time what's going to happen to all of the assets and how everything's going to be divided in the event they go down that road. And so we have what's called an agreement incident to divorce, which can be really helpful because there's sometimes concerns if you do a postnup and the parties are contemplating a divorce, is that going to be something that's going to hold up? So you want to be somewhat cautious of that if one party knows they're getting a divorce, and what your state law is going to be like with that. So also, what about kids? Do you know, like I know in Texas, we can't contract with respect to child-related issues in a premarital agreement or postmarital agreement. That's not going to be enforceable. But what about Florida?
Yeah, in Florida, it's the same way. In Florida, they view any issues pertaining to the children as really being under the jurisdiction of the court. And the court has to make that determination in terms of what's in the best interest of the children when it's looking at a parenting plan. Another word for it in your jurisdiction might be custody, time sharing, they're all interchanged. And that's why I think it's so important if you are looking for advice on a postnuptial, a prenuptial, or even just the divorce or separation process to get a consultation because each jurisdiction can be different. But that's one thing that I think that is extremely important for the parties to start thinking about. But it certainly isn't something that most of the times you're going to be able to contract away, because you might agree 10 years ago what you're going to do as in relation to the overnights, the holidays, etc. A lot can change in that time, and I think the courts want there to be a jurisdiction and ability for them to take a look at it and determine whether or not it's going to be in the best interest of the children. So for the postnuptial and the prenuptial, I'm thinking, you're really looking at the assets, liabilities, spousal support, and everything in between.
Yeah, I mean, I don't think it necessarily harms you to put some of those thoughts in an agreement. I mean, I always tell clients when I'm doing a postnup or prenup, you can feel free to get creative on it. You can pretty much contract to most anything related to those types of issues. And we certainly have, I have a list of things that I go through with them to make sure that they're considering when they're doing a postnup or a prenup. But, if I draft really customized postnups, prenups all the time, agreements incident to divorce all the time. And if you do end up putting some custody stuff in there, I mean, know that the court doesn't have to follow that. It's not enforceable really. But just because that part isn't enforceable doesn't mean that the other stuff isn't enforceable. So if one part of a contract is generally found to be unenforceable, it doesn't make the whole thing unenforceable on a prenup or postnup for the most part. As always, you want to consult your state. Things are very state specific, and including enforcement of agreements to that effect. But you can really save yourself a lot of time and money and turmoil having a good prenup or postnup. And I'm always surprised that we don't do more of them. I mean, especially when I have clients that get a divorce and then they get remarried. And then I have them back in a few years and it's like, oh, I told you to get a prenup. So it's always a good thing, especially, and if you have assets, I mean, I know a lot of people get married younger when they don't have a lot of stuff and they don't think they need it. But you're going to earn income throughout your life and probably not be have a little bit more later on in life than you will. So it's a good idea to get it. Any other thoughts on prenups and postnups?
Yeah, I mean, when it comes to a postnuptial, a lot of people think, oh, well, I'm getting married in a week, right? I need to get this done. I've always been of the understanding that if you know you're going to marry somebody and you have that ring and you know this is somebody you want to spend the rest of your life with, I think the financial aspect of it and having that open communication ahead of time is going to be very important. And postnuptials just aren't drafted, in a manner that's going to be expedited. There needs to be a full and frank disclosure. There needs to be an understanding between the parties. Your attorney needs time to be able to review the documents, make sure that the other side, the other party, if they have an attorney, reviews the documents. And a lot of these things should be done probably prior to you planning for your wedding, right? You want the postnuptial or prenuptial in this circumstance to be something where you've worked on it, you've finalized it, you've gone back and forth, there's been a full and frank disclosure, and your attorney then can advise you on a little bit of that creativity that you touched on. Is there certain things that we want to waive in there, such as appreciation, marital appreciation on a non-marital asset? Do we want to consider spousal support? Is there any trusts or any type of businesses that might be family run or businesses that you might be a part of now that you might not want that to be considered later on? And that takes time, right? And so when it comes to the postnuptial, I think it's really important if you're in those stages of preparing to get engaged, preparing for that wedding, that you want to do this way ahead of time. And the thought behind it is you're never going to use it, right? And it's only for those circumstances where something does go wrong, and then you have to pull it out. And like you said earlier, it saves you time, it saves you money, it addresses a lot of the concerns already. And if you've done it the right way, you should feel very comfortable in it being upheld and the validity of it, because you want to spend that time planning and being ready for the wedding. You don't want to interrupt that with the drafting of a postnuptial. So I think timing is very, very important when it comes to drafting it and making sure you take the right requisite steps so that you're not going to have any issues in the future.
Yeah, and that's true. Like with postnups, I think some of our viewers are probably going to be past that point at this point. But if you're thinking about a postnup or an agreement incident divorce, like with Mel's situation, maybe he could not have saved that $425 million that he ended up having to get go through. But later in their marriage, they could have done a postnup or an agreement incident divorce or something that might have saved his royalty income as that was coming in, and also spousal, if there's a concern regarding spousal maintenance. I know, Texas kind of moving into spousal support and what you might need to know about spousal maintenance. Texas, we're not a big spousal support a state. And I when I go to seminars and things, Texas attorneys are sort of always the envy of a lot of other states, because we don't, our support is really based on minimum reasonable needs. It's hard to get, and if you're married under 10 years. So it's very, very limited in Texas as to what somebody can get for spousal maintenance. But my understanding is in many other states, it's a lot bigger issue. And even somebody in Mel Gibson's case, like his wife, even if, Robyn is getting all these millions in some states, she might still qualify for some level of spousal support.
Yeah. And in Florida is one of the Wild West when it comes to spousal support. And last year there was actually a bill change that took away permanent alimony. But if you're in a long-term marriage over 20 years, you're looking at a 75% as the maximum in terms of the range and the length in which the spousal support obligation can continue, right? And obviously that's the maximum, but they're also looking at a 35% difference between the net incomes. And obviously planning ahead of time in a postnuptial or prenuptial is going to be a huge benefit, because you're taking the guess out of the court, right? By not allowing a judge to come in and hit you with the maximum, right? Or vice versa, if you're on the other side, hit you with the minimum. So I think when it comes to the spousal support maintenance, every state has a different kind of view on this, but it's really going to be based on the spouse's need for it and the other spouse's ability to pay. And coming into a post-nuptial, if you have assets, if you have a business income, et cetera, that could be something that is hotly contested in the divorce. And if it's something that could be resolved prior through an agreement, you're always in the benefit there.
Yeah. And I always kind of try to tell clients, especially if they're in a situation like poor old Mel, where, he was the primary earner, and I'm assuming his wife did not have employment pretty much for the entirety of their marriage with 7 kids. I can't imagine somebody had to be home with those kiddos. So, when we, especially in Texas, when we have a situation where one parent or one party has been sort of a stay at home, if we're representing the guy and the wife has been a stay at home parent, one of the best things that they can do in strategizing is try to encourage her to go back to work, try to encourage her to go start school or get some kind of means of employment, especially if you're looking, you've got some older kids, you guys have been married more than 10 years, and spousal maintenance is certainly going to be an issue. If you can encourage your spouse to get out and get employed and start making a reasonable income, that's going to be hugely beneficial for a case when spousal maintenance is at issue.
Yeah, and I agree. I think when it comes to the need of the other spouse, the court is going to take into consideration the caretaking, et cetera. And regardless of the spousal support that might be ordered, both parties' standards of living are going to be much lower. And usually that spouse that's on the receiving end, in order to maintain that same standard of living, is going to have to get a job. And I think that when the children are older, looking into trying to find the other, your spouse to seek employment, some type of educational degree. I know a lot of my military guys have the GI Bill that can be transferred to the spouse in terms of education. Anything that you can do to try and show that if the divorce proceeding is ongoing and your wife is not working or the spouse is not working on the other side, you have to find a way to be creative to maybe inform the court that this party's voluntarily underemployed or unemployed. And this is the things that they can be doing. These are the occupations that they can be, and that's working with your attorney in terms of maybe even seeking an expert to do some type of vocational evaluation to show the court, even though my spouse is at a 0 when it looks like on her financial affidavit, or she's at a 0 in terms of income, this is what she could be making. And oftentimes the court can impute income to that other party, which again, anything to lower that need or your ability to pay is going to be a big benefit to you.
Yeah. And, it kind of talking about preparing for a divorce, living situation is another big issue that I have come up. Well, we're getting ready to separate. Should I move out of the house? Should I stay? Mel and his wife had, I assume, several properties. She definitely got one of them. If you've got a couple of different properties and residences, if you've got one rental income, one rental home or one property, and you have more than one, even within those situations, I always kind of, be careful. And that's one of the things that we have a 10 stupidest mistakes guys make. And one of them is moving out of the house too quickly. You're ceding a lot of really great ground. I mean, a lot of your biggest bargaining chips are the fact that you're still in the house. And once you move out of the house, and even if you guys have a rental income, I have guys move into RVs all the time before they file for divorce. And then the wife doesn't let him see the kids. And so now we're 2 months down the line. He's living in an RV, paying all of the mortgage and everything for a house he's not living in. And he's not even really seeing the kids. And it takes us, and we're lucky in Texas that we can get into court relatively quickly. But I've seen some other states that, it's really hard to get in for temporary orders for possession and access. So, when you're talking about moving forward with a divorce and you've got some property there, What do you tell your clients, Enrico, about kind of anticipating how those living conditions are going to get and how they might split actual real estate as well?
Yeah, and I think you hit it on the head, Kelly. Moving out during the divorce process when you're living with your spouse can be a big negative. I mean, you're taking on all of these additional expenses. Not only you're taking on those expenses, you're usually contributing or paying for all the expenses at the household. And then you get into a situation that you brought up where all of a sudden now you're pigeonholed. You're only seeing the kids on the weekends. You're only seeing the kids when the mom or the opposing party is dictating the schedule to you. And unless it's an emergency in some counties, in some jurisdictions, it could take a long time to get that temporary relief to get you to a set parenting plan. And that becomes the issue is now these kids, there's a routine, there's a custom, there's a standard that has been taking place because you've moved out, right? And I think that's going to be an important aspect. If you can stay together within the household, you're having those overnights, you're having that substantial time, and it benefits you later on down the road, right? The only really reason to be moving out of the house is going to be some type of domestic abuse or some type of incident that would cause you to have to either leave because you're in fear of your life, your safety, your well-being, or your children's safety and well-being. But absent that, there's no reason why two parties shouldn't reside together in the same household. Now, if you've already moved out, if you're already there, I think it's extremely important to start a parenting plan that is at least equal, to have that consistent routine, that pick up and drop off. And if the opposing party, the other side, is denying you that time, you continue to make those requests in writing. So then when you have that opportunity to go into court, it's not because, I didn't want to see them, or, I didn't want these overnights. It's I've consistently asked for it and the other party is not working with me on it, right? And I think when it comes to the time sharing, when you're thinking about these things in a divorce process, a paternity matter, when anything's related to the children, you have to start being a little bit more methodical. You have to start being there for your kids. And most of the time, our guys are always there. They don't even realize how much they do. And I make them write down and journal an entire week of what they do with the kids. And they'd be amazed at how much it actually is, right? And get that essential time that you need with your children or your child. Make sure that you're attending the doctor's visits. Make sure that you're there for the pickup and drop off the best that you can be. Attending any medical visits, dental visits, going to any extracurricular activities, learning who their friends are, writing down what the routine is, either at home where you're there in the family unit in the residence, or if you're in your own place where the child sleeps, what they eat, what they do. Those are all the things that are going to be important because most states, depending on the jurisdiction, the court has to look at what's in the best interest of those children. And you want to be able to testify regarding what's in the best interest of the children. And who better to know that than the father, right?
Yeah, and if you're not living in the home, that's a little bit of a bigger stretch. So even if in Mel's case, like they probably knew she was going to get that house. They probably had talked about it during the split that she was going to get that house. And I have plenty of clients who come in going, "Wait, yeah, my wife's probably going to get the house, and I'm going to do this, and I'm going to do that." You still want to be strategizing with your attorney as to when the best time to make that happen is going to be. Because like I said, and like Enrico was talking about, it's just a huge strategy move to just move out of the house. So it may be that she's going to get the house, but you want to have a little bit more control over the strategy as to when that happens. And so kind of moving along a little bit, I want to get to some more topics. In Mel's case, he actually got a DUI during the divorce case. And so I think it may have been the big famous one that he got in quite a bit of trouble for. But I know it was at least one DUI that he got during that divorce case. I think she filed like the day after it happened. But anyway, how does that, when you have something like that happen, or you have a substance abuse issue happen, and that that's going to be an issue in the divorce case, how do you strategize, or what do you do if that's going to be an issue in a case?
You just have to be on your best behavior, right? You got to think of this as anything that could go wrong, anything that you do during this process, it can be used against you, right? And I think when it comes to any type of drinking, any type of going out, any type of communication via text message, what you do on social media, these are all things that can be used against you and also for you, right? And when you're going through this process, if you know that the opposing party has alleged allegations of drinking, drug abuse, mental instability, anything related to a wide variety of topics, you need to be doing the opposite. This is a time for you in the process to work with your attorney on addressing any of these concerns and rebutting them. There's been several cases where these wild allegations of drinking or drug usage or going out or not being able to pick up the children were pled for in the opposing party's petition. And during the process, strategizing with my client or strategizing with your attorney, you're going to be coming up with ways to show the court, well, she alleged this, but look what happened in those next 6 months, right? Maybe you went on SoberLink and you didn't blow positive any of those times. Or maybe there was an anger management issue that was alleged that has no basis, but you know what? You took an anger management course. Anything that you can do above and beyond to rebut these claims of the opposing side is going to be a benefit to you. But when it comes to social media, when it comes to communication, when it comes to going out, when it comes to text messages with the opposing party, it's so important to realize that those things can be used for or against you. And make sure that you're communicating about the children, right? Thank you for picking the child up, or I appreciate you doing this. You have to find a way to co-parent, be effective in your communication, because you don't want things to come out later on in the courtroom regarding what you posted, what you did, right? And I think having a smart attorney to work with you on those strategies, especially if there's some wild allegations that might not be based in truth, those are things that need to be worked on with your attorney to kind of rebut, and then obviously to show the court how this is not true.
Yeah. And I always, it's very, very, very important for anytime you have one of these issues, especially, I mean, it's always important to strategize with your lawyer, but one of the biggest things is don't lie to your lawyer. Don't keep stuff from your lawyer, because we have a lot of experience on how judges react and how they deal with these things and what they like to hear. And a lot of the times I can dig clients, out of some holes if I know the honest truth, and they will listen to me about kind of here's the best way to deal with it. So there are some times when you have to admit responsibility and you have to take responsibility for those actions. And there's just no way, the judge wants to hear that, hey, I may have had this issue. I'm, in the past I've had that. These are all the things I've done to overcome this issue. And then there are other times when it's just an allegation and it's not really based in fact, that you want to be more defensive about it. But that's going to be largely based on what evidence there is against you and like what the other side is going to bring and how believable they're going to be. Because a lot of this stuff is your word against the other side's word. And so, but I have clients all the time that they don't want to admit that they've got this issue. Well, the judge is going to know. The judge is they're going to hear it. There's evidence there that I'm telling the client, like, look, this is enough here. A judge is going to be concerned. So strategically, this is how we need to handle it. And I've had clients that 180'd in a case, went from having protective orders against them to ending up with primary conservatorship of the child. Now, obviously, we can't do that in every case. It's not but that's listening to your attorney over years of time, just rebuilding and mom not doing what she needs to be doing and dad doing everything that he needs to be doing. And over time, those things we can really repair a lot of damaging issues in a case.
I agree.
Okay. Don't forget, if you have any questions, please put them in the comments and make sure that we're here to answer any questions that anybody has about any of these issues. Just as a reminder, just kind of moving along, we are almost out of time, but just a little bit of time left. I wanted to touch on one more thing. Gibson reportedly stated they settled in his case, and he stated in it, I ended it for my children and my family. This was going to be such a circus, and you just don't drag other people in your life through the sewer needlessly. So I'll take the hit and move on. So he settled his case, and I know that I have a lot of clients that come in and kind of want to give the world and want to settle really quickly. And so what, Rico, do you say to clients that come in and they're just like, I don't want to litigate. I want to settle. I want to give her whatever she wants.
I think the most important thing is to explain exactly statutorily what you're going to be receiving. Now, obviously, we can't give assurance as to what a judge is going to do. But generally, in the state of Florida, you're looking at some type of 50-50 split. And if you start right off the back by saying, well, I want to give the opposing party everything that they want, and I want to move forward, right, you might be doing yourself a disservice down the road, right, including with your parenting plan. And a lot of the assets and a lot of the things related to liabilities and assets and anything within the equitable distribution or the community property scheme, there's no modifying that. Right? When that's done, it's done. And especially in a parenting plan situation, oftentimes when that's entered, it becomes very difficult to modify, right? And I think that becomes a very, very big issue is why are you giving up these things when maybe in court you're not going to get them? So I think if you're ever in a position with a client and you want to just get it done, you want to settle, you have a child, you've been married for a long period of time. The divorce might take a little bit longer, but you might be better off for it in the long run if you follow those directions. Now, at the end of the day, you are leading the ship. And if you have the advice of this is what you're going to get, this is what you're going to do, this is what the court's going to do, and you still don't want to follow that legal advice, then obviously you have the right to do that. But I would be very hesitant to say that they should accept a settlement or accept something in which they're going to get less. Because then you're going to be thinking 2 years, 3 years down the road, why did I do that? Why did I give that up? Or in a situation of a parenting plan where you give up most of your overnights just to be done with it, thinking that, oh, well, mom and I are fine now. Well, 2 years down the road, all of a sudden, that little oral agreement that you guys have been doing, now she's off and sticking you to the parenting plan. And do you have a basis to modify now? Or are you going to be spending more later on to fix the mistake you made in the divorce? Right. So I think everybody wants the process to be quick. I think everybody wants to be done with it the minute they start with it, but it takes time. Right. And working with your attorney, having patience, doing the right thing often pays off in the long run and saves you a lot of money in the long run.
Yeah. And I always kind of tell people this especially when in initial consultations, when they're trying to rush through it or they have rushed through it, it's a lot easier. It's a lot easier and cheaper to prevent you from falling in a hole than to dig out of one. So, and another thing I think that is really important is being careful not to promise things early on in the case. So when you're talking, you're sitting your spouse down and you're talking about this divorce and you're talking about, well, what do I get? What do you get? What will I be willing to do? What will you be willing to do? This is a little bit of a poker game, and it's a hope for the best, prepare for the worst kind of situation. I mean, hopefully everybody you settle, everybody reaches a good agreement that's workable for everyone. That would be great. It's best for, you, it's best for your kids. But if you do some damage to your case, you're not only damaging your livelihood for the rest of your life, you could potentially be damaging your relationship with your kids for the rest of their lives. So it's very important not to promise things early up front, especially before talking to an attorney and knowing what your rights are and knowing what kind of you should be getting. And there's certainly cost benefits, right? I mean, there's certainly situations where we're like, hey, it's going to cost you more in court than to go ahead and settle on this issue, but you want to be getting really good advice for that. So, so it doesn't look like we've had too many questions. So we're about out of time for today. So any other last comments, Enrico?
No, I just think that, if this is something where you're considering a postnuptial, a prenuptial, you're considering a legal separation, a divorce, get a consultation, right? And for us, I think that, what makes us different than most other firms is the fact that we represent men. And most importantly, we're a large firm that only practices and specializes in this field, right? And that's somebody that I think for anybody that's looking to see what they want to do, get a consultation, find out the information. And you can't just sometimes Google and look into these things. You're going to want to sit down, speak to an attorney that's competent in your jurisdiction that only handles that. And that's what we do.
Yeah, absolutely. And if you are interested in getting a consultation, please visit cordellcordell.com, or call us at 1-866-DADS-LAW so you can get in contact with a Cordell & Cordell attorney near you. It's really important to get that advice early on. So whether you decide you need an attorney right now or not, the consultations are available and you get a lot of really great information. So just a reminder, this was brought to you by Men's Divorce Podcast. archive of our previous men's divorce podcast sessions are online. Please feel free to visit them for all kinds of really great information. The live webinar today is presented and produced by Lexicon, a legal technology company. Thank you, Enrico, for joining us today. I hope everyone out there had some helpful information, and please feel free to join us again.
Thank you, Kelly.